Good morning, everyone. Thank you, Michael, for inviting me to this workshop. I'm a lawyer by training and I do legal scholarship, so I have enjoyed listening to DH scholars over the last 2 days and I've learned a lot. So a lot of the things that there might be some ignorance in what I say regarding machine learning, AI, text and data mining, but forgive me, I am a legal scholar. So today I want to speak about copyright ethics in an age of AI. And essentially what I really want to talk about is the issue of consent, credit, and compensation to the author of copyrighted works or copyright owners, and whether we need to have that to be in line with the ethics of copyright, whether the ethics of copyright always require consent, compensation, and credit. And so today I would be looking at copyright, or I'll be using copyright in two senses, and I think this is important to sort of clarify the misconception that copyrighted, we must always get credit, consent, and pay compensation for the use of copyrighted works. So I use copyright in the narrow sense of a legal right that, or a bundle of legal rights that are granted to the creators of an eligible subject matter for copyright. And then I would also use copyright in a broad sense. So when I talk about copyright ethics, I'm really using it in the broad sense of a legal framework, because most people think about copyright in that narrow sense of a right, but I would like to talk about copyright in the broader sense of a legal framework from which creators and others, not just creators, but creators and other people actually derive some legal rights from the copyright framework. So the copyright framework is a framework for both creators and users, because the copyright framework essentially reflects what we call a social contract. And it's a social contract between creators and users of copyrighted works. Or more aptly, even though we like to think of copyright as really benefiting creators, corporate actors are the ones who really use copyright the most. So maybe more aptly a social contract between corporate actors or publishers and distributors, intermediaries, and users. So I would like to talk a bit about what sort of gave rise to this social contract, the pre-copyright landscape. So creative works are essentially, in copyright parlance, we would call them expressions of ideas, expressions of information. And pre-copyright, once the idea is expressed in a way that is available to the public, you really cannot stop people from copying and using the idea and the expression. And also copying or using a creative work, which we would in legal parlance call an intangible property, even though a literary work may be embedded in a book or it may be embedded in a particular device, the property that is being protected through the copyright framework is really not a physical property. So the way we envision intangible property and rights in intangible property are sort of different from the way in which we envision rights in physical property. And so for intangible property, for creative works as intangible property, when another person copies or uses that particular work, we like to think that it doesn't diminish or deprive the creator or anyone else of enjoying the idea that they've expressed in that particular work. That the creator could express an idea in a particular work and enjoy that particular idea. I could pick that particular novel and read it and enjoy it, and you could pick it, and my enjoyment is not diminished by your enjoyment of that particular novel. And in this sense, we would consider creative works as having two essential characteristics, that they are non-excludable. Once you have the idea expressed, you really can't exclude somebody else from using the idea or the information or the facts that have been presented in a particular creative work. And we would also say creative work as intangible property also have the characteristics of being non-rivalrous, that a person's enjoyment of the work does not diminish or affect another person's enjoyment of the work. So thinking a world without the copyright framework, if I had an idea for a novel and I put down the idea and wrote the novel and published it, I cannot stop anyone who reads the novel from using the ideas that I have expressed or the information in that particular novel and doing whatsoever they want with it. If I have a copy of the novel, I can stop someone from stealing that because that's a physical property, but the copyright, the intangible property, in a world without copyright, I really can't stop anyone from doing anything with it. So if someone visited a friend who has that particular novel pre-copyright, I really can't stop that person from making a copy of that particular novel and taking it with them and using it, as long as they do not steal my own copy, which would be a subject matter of physical property, not even intangible, theft of intangible property. So when authors write, they would usually sell their manuscripts to publishers who then became concerned that they could not make maximum profits in a world where you couldn't exclude other people from using that particular, from reproducing that particular work, especially in the 18th century era of mechanical copying. So in England, the Stationers' Company, which is the printing and publishing press, lobbied for the grant of incentives or for the development of a framework to allow them to actually print and publish work without having to deal with any competitor printing and publishing the same work. And they lobbied this as something that they were really advocating for as an author's right, but in actual fact, it wasn't really an author's right. Authors would usually sell their manuscripts to publishers, to printers, and printers would market that. So it was deemed that it was going to be a right that was transferable by creators to publishers, and publishers would exploit that particular right. So the resultant system of incentives from this lobbying was the copyright framework. But like I said, that framework was really not designed with the novelist in mind or with the creator in mind alone, but it was also designed with the users in mind, because pre-copyright, you had a landscape or you had a state of affairs where users could pretty much do anything they want with a work that has been created. So the framers of the copyright system, especially Anglo-European copyright, then decided to sort of strike a balance between the existing position of users who have this free reign on the use of works and the push by the Stationers' Company to sort of restrict the existing rights that users have. So it was really a social contract between the creators or the publishers and the public, incentivizing and encouraging the creation and dissemination of original works of literature at the time, but now music, visual arts, software, and many other things that copyright now protect. It is, however, important to note that the copyright framework did not create a general right of remuneration. So in the original Copyright Act, there was no right of remuneration whatsoever. Copyright simply establishes limited exclusive rights for creators to perform certain acts in relation to their works, which creators may then exchange for whatever value the market ascribes to it. So copyright was not designed to really give creators remuneration. You could use it as a tool for remuneration. It was also not designed essentially for you to always use it as an exclusionary tool. It was sort of designed as this neutral framework where you could decide to use it as an exclusionary tool, but you could also decide to use it as an inclusionary tool. So on the other side of the copyright balance, the protection of the public interest in having access to works was also woven into the copyright system. So what we had was the copyright system established rights for creators or publishers when the right is transferred from the creators to publishers, but also established user rights to make certain uses of the protected works, and established a public domain in which certain works were not protected. And even for works that were protected, certain elements of protected works were not protected. So you had, at this public domain, you had user rights. So the preamble of the Statute of Anne, the first English copyright statute, is telling. It was really an act for the encouragement of learning. We wanted people to continue to create works and to disseminate those works, but the publishers who were in charge of publishing those works would not necessarily publish those works unless they have this exclusive right. So we're like, okay, we want to continue to encourage learning. We want to continue to encourage people to read works, to engage with works of art and intellect, but we would then have this copyright. So we would do this by vesting the copies of printed books in the authors or purchasers here being printers and booksellers during the times mentioned in the Statute of Anne. So what were the terms of the social contracts reflected in the Statute of Anne? You had creators given the sole rights to copy books for a limited time. So they had the rights to print, to mechanically reproduce books for a limited time. That was the rights that was given to creators. But on the user side, in the Statute of Anne, you also had these rights that were given to users. So the limited term of copyright ensured that users, after a period of time, could actually do what they could do in the copyright landscape, in the pre-copyright landscape, with copyrighted works. So the maximum possible protection you could get under the Statute of Anne was 28 years after the work was created or was published. And under the Statute of Anne, we also had a limited right. So it wasn't that the copyright owner could exclude people from doing every and anything with the work. They could only exclude people from copying the work. So then we didn't even have an exclusive right of translation. We didn't have an exclusive right of adaptation. All you had was an exclusive right to copy. And then the subject matter was limited. It only applied to books. So if you had music, copyright did not attach to music. It didn't attach to other forms of art. And then you had price regulation in that particular statute. Again, a user right saying if users of copyrighted works think that the price attached to a work is high and unreasonable, there was a complaints procedure. And under that complaints procedure, you could actually reduce the price of work. So it wasn't left to creators to design that particular price. And then you had access through libraries. The role of libraries or being able to access works through libraries was something that was important under the Statute of Anne, so that people were not compelled to actually access works through purchase, but creators were mandated to deposit 9 copies of their work to 9 libraries in Great Britain at the time. So that was the landscape, that was the social contract. So we had a system, a framework that created rights and obligations for creators, but also rights and obligations for users, for the public. So the terms of the copyrights the term of the social contracts and copyrights has evolved over the years. It's evolved in a lopsided manner. I mean, when you think of what you know about copyright today, it's far different from what we had in the Statute of Anne. And most of this, so it's sort of involved in a way where publishers and creators have far more rights than users have today. Most of this really stemmed from the globalization of copyright law. There are international copyright laws that countries are party to that mandate that they have some minimum requirements or some minimum protections for authors, and those laws are not really balanced with a lot of protections for users. But notwithstanding this, the copyright framework still reflects this social contract. And so if we look at the Canadian Copyright Act today, we would also see that the Canadian Copyright Act still sets out rights and obligations for both creators and users. So for creators have this exclusive rights to, now 400 years later, to publish, to copy, to make available to the public, to communicate to the public, to perform, to translate the whole or substantial part of their work for a limited time. And they have the rights to authorize the doing of any of these things. Since 2012 in Canada, creators also have the right to use technological protection measures, to use digital locks to prevent access to their works. And these locks are protected through what we call anti-circumvention provisions in the Copyright Act. And creators also have moral rights, the right to be acknowledged as the author of the work, or not to be acknowledged as the author of the work, the right to the integrity of their work, not to do anything that would affect their reputation. Think of the Eaton Center and the flying geese, and the case of the ribbon being tied to the flying geese, and the sculptor saying that that's an infringement of their copyright. But the aspect of copyright is their moral right. So that's what we have now. But we also have rights. If you go to Part 2 of the Copyright Act, you would actually see that we also have user rights in the copyright framework. And one of the important user rights that we have in that framework is this idea expression dichotomy, which is important when we think of AI training, text and data mining, And it's the idea that copyright does not reside in ideas, information, facts, data, and styles. And that when all of these things are contained in a work, you could take the ideas, you could take the information, you could take the facts, you could take the data and the style, and you wouldn't need to get the consent of the copyright owner. This is a user right. What is protected essentially is the way in which these things are expressed. As long as the expression is not taken, there is no copyright infringement. So I could decide a person could write a recipe book, and I could take the ideas in the recipe book and create a really nice dish and open a restaurant with that, and they wouldn't be able to sue me for copyright infringement because copyright law does not protect that. That's a user right. And so you also have the user right of insubstantial copying and use. So under copyright law, you do not need to get permission for every form of copying. So even if you're copying an expression in a particular work, what the creator has is an exclusive right to the whole or a substantial part of the work. So if you're doing insubstantial copying, insubstantial publishing, insubstantial translation, that's not something for which you require a copyright license. But we also have the limited rights. So the scope of the rights, even though it's more expansive than what you had under the Statutes of Anne, is really not unlimited. It's still a limited right. So for instance, we do not have creators or copyright owners do not have a right to read. So I could walk into a bookstore and decide to actually flip through pages of book and read it without getting the permission of the copyright owner, as long as the owner of the copy of the book, who is not really the copyright owner, is happy with that. I could go to the library and read a book, and the library does not need to get copyright permission because that's not a right of the copyright owner. So, and we don't have perpetual copyright, even though we have long term of copyright. It's moved from 28 years now in Canada to the life of the author plus 70 years after the end of the year in which the author died, which is really a long period of time, but it's still not perpetual copyright. At some point, works fall into the public domain. So in Canada, on January 1 every year, some works would usually fall into the public domain. And so we also have what we call copyright exceptions or user rights properly so called in the Copyright Act, think fair dealing, or in the US, fair use. That also allows you to do something with protected works when you're going to copy something that is substantial or there is the whole or a substantial part of a work. You still have some rights related to copying the whole or a substantial part of a work if you can come under some specific exceptions. So all this to say that in copyright ethics, unauthorized copying, unauthorized use of a work could actually be lawful based on the framework of the Copyright Act, based on this balance that the Copyright Act tries to strike between the rights of authors and those of users. And the Supreme Court of Canada, this has been challenged a couple of times at the Supreme Court of Canada, and the Supreme Court has reiterated the fact that the Copyright Act is really a balance between promoting the public interest in encouraging and disseminating works and obtaining a just reward for the author, and that the proper balance among this and other public objectives of the Copyright Act lies not only in recognizing creators' rights, because most people think the copyright system should only recognize creators' rights or recognizes only creators' rights, but in actually giving due weight to their limited nature, that these rights are not absolute rights, they are limited rights, and because they are limited rights, users have some rights under copyright law. So I would like to say that copyright ethics involves respecting the terms of the social contract created by the scheme of copyright law, and it involves ensuring that the terms of this contract reflect the balancing of rights of the rights or interests of both creators and users. So it's really involves respecting the duality of copyright protection, that copyright is really used in the act in a broad sense of a framework of rights for creators, but also for users. And so copyright ethics demands that the rights of copyright owners be limited to ensure the sustainability of the copyright system, and also to ensure that the copyright system does not really defeat its own ends of encouraging learning, of encouraging access to works, encouraging dissemination, encouraging the use of works for creative purposes. So like I've said repeatedly, in copyright law, unauthorized, unpaid, and unacknowledged copying can be lawful and ethical. The issue is not whether we have the 3 Cs whenever we're using a copyrighted work. The issue is whether the code of copyright ethics has been violated by the person who is using the work. So I would like to expand on 2 user rights, or maybe one, the fair dealing rights in Canada. So this is a quote from the Copyright Act. It's not a paraphrase. Fair dealing for the purpose of research, private study, education, parody, or satire does not infringe copyright. So you have that in the Copyright Act. Fair dealing for the purpose of criticism, review, news reporting does not infringe Copyright Act. And you would actually see that in the second fair dealing provision, you have the requirements of acknowledging source, of acknowledging what the name of the author is, and all of that. But in the first part, you could actually use a work for research, for private study, for education, for parody or satire, without a requirement to acknowledge source, without a requirement to comply with the moral rights, because the moral right is limited in that particular instance. So if the use of a work constitutes fair dealing for any of these purposes in Canada, you do not require the permission of the copyright owner. And fair dealing is not just a loophole in the Copyright Act. It's actually an affirmative right. It's not just a defense that you raise when there is copyright infringement. It's a right that empowers you to do something even when you have not been sued for copyright infringement. So that's the nature of the fair dealing. So for people engaged in text and data mining activities, for machine learning activities, the question is what you're doing within the framework of, say, the fair dealing provision or of any of the user rights in copyright law? Because if it is, then you're not infringing on copyright. And the presence of a license from the copyright owner for an activity that does not infringe copyright does not obviate, the rights that you already have. And the Supreme Court has said the mere fact that a publisher is offering licenses to do something that the Copyright Act says you do not need the permission of the copyright owner for, does not mean you really have to get that particular license. So we have the purposes in which you must bring your activity within, and for these purposes, the Supreme Court of Canada said for us to have that social contract that the Copyright Act really seeks to uphold, user rights cannot be unduly constrained. So if you're talking about research must be given a broad and liberal interpretation. Research is not limited to non-commercial research, for instance. So in the seminal case or in the most popular case on fair dealing in Canada, it was a case that involved the use of copyrighted materials for research purposes by lawyers, and the argument that was made by Access Copyright, a group of publishers or an association representing publishers, is that lawyers were using those research materials to give clients advice, and we're getting money from that. And the court said, well, there is nothing in the Copyright Act that prevents us from using the fair dealing exception for commercial purposes. And it was also said that research was in another case in Sokan and Bell, the copyright owners sought to present an argument where research would be interpreted in a manner that is really narrow. So in that case, it was a case where Bell Canada was making available 30 to 90 seconds of music on their website so that people can listen to it before deciding whether or not they want to purchase a song. And copyright owners argued that that was an infringement of copyright, and the court said no, that was fair dealing for research purposes. That particular feature enabled people to actually conduct research into the music they want to buy, similar to walking into a bookstore and actually being able to read some parts before deciding whether you wanted to buy a book. So the Supreme Court has interpreted research and other purposes in a very liberal manner. So, but in addition to bringing your purposes within the scope of those purposes under Section 29 and 29.1 of the Copyright Act, your use of the work must also be fair. So this is where it then becomes challenging. What constitutes fairness in copyright law? What constitutes fairness for the purpose of fair dealing? The Supreme Court of Canada has highlighted 6 factors that we would consider in determining whether the use of a work is fair, and these factors are not exhaustive. Some factors, as the Supreme Court has stated, could be important in some regard, and they could be completely irrelevant in some circumstances. So we look at the purpose of the dealing, what's really the real motive behind using that particular work. The Supreme Court wants to know what's the purpose behind using that particular work. There must be a genuine purpose regarding the use of that particular work. There is not contrary to those purposes listed under Section 29. What's the character of the dealing? How is the work dealt with? Is it dealt with in a manner where members of the public would have access to copies of that work in a way that would affect the market of the work? Or is it dealt with in a manner where members of the public would have access to that particular work and be able to use it for certain purposes that do not necessarily set up competition with the market for the underlying works? But again, the Supreme Court has stated that the mere fact that the use of a work would prevent certain categories of persons from buying copies of that work does not necessarily mean that the dealing with the work is unfair. The amount of the delay is something that the court would consider, but remember that the court is considering whether your substantial copying constitutes fair dealing, because if it's insubstantial copying, you don't even need we don't even have to bring up fair dealing. So the court under this particular factor is not considering whether is considering the amount, but the mere fact that you've copied the entirety of your work does not prevent you from applying the fair dealing. For instance, the court has said that there are situations where you have to copy the whole of a work to use it for research purposes or to use it for criticism or review, and that the nature of some works like photographs necessarily involve copying the entirety of the work. So the mere fact that you've copied the entirety of a work does not mean that you've infringed on the copyright. And then the court talks about whether there are alternatives way in which you could have dealt with the work. Perhaps there are public domain materials that contain the same idea and the same information as those contained in the work that you've used, and the court would say, it's fair for you to use the public domain material rather than the in-copyright material. But there are cases when there are no substitutes, or the kind of project you're working on involves using a large data set, and you wouldn't be representing the particular data group that you are trying to work on without using non-public domain materials. So the court also considers the nature of the work. Is it a work that is confidential? Is it a work that has been published? Fair dealing leans more towards a work that has been made available to the public by the copyright owner. And also the effect of the dealing of the work, which is really the effect of the dealing on the market of the work. But the court has said this is the most irrelevant factor when it comes to the fair dealing analysis. And there is a lot to be said about fair dealing because it's a contextual analysis, it's a fact-based analysis, and so it depends on the fact of the case. But to just get people thinking about the kind of projects that they work on and whether or not they need copyright licenses for those projects or not. So if we want to develop ethical and responsible AI tools, or as Brad said, AI toys, the kind of training data that is available and accessible becomes important. If we decide to shift the bargain that copyrights represent, and we say, things that do not necessarily require the permission or payments to the copyright owners, we should bring that into the column of things that now require payments to the copyright owner. What does that do for accessibility of data? The truth is, corporate actors, big tech corporations would always be able to afford to buy a data set if we decide to commercialize it, if we decide to move the copyright balance or move some things to the author or the publisher side. The people that would really be affected are small creators who really want to use these data sets to create new works. There are people who cannot necessarily afford to buy large data sets or to pay for data sets. So those are the people that would be affected. And in that way, we might think of, are we really widening the knowledge or the digital divide, making it possible for an elite class of people to be able to do AI research, to do works related to AI development, if we begin to push that kind of argument. The public interest value in developing ethical and responsible AI systems that are open and accessible to everyone, I would argue, necessitates having open and accessible training data. I would also argue that the policies and laws that must be adopted to advance AI ethics must not erode or override the public interest in the access, use, and dissemination of information, including those that are embedded in copyright works. And while supporting creators and cultural production remains important, and why it's still something that copyright law does, we must not make the mistake of assuming that granting more rights to copyright owners to prohibit the use of their works as sources of information and objects of analysis would benefit creators, because over time we've seen that that's not what happens. If we go back to 1996, when the Treaty on Technological Protection Measures were developed, the argument was that this was going to protect creators, but the people who have really taken advantage of this are publishers, are intermediaries. So copyright has really never helped the struggling artists. It has given more power to people who exploit the struggling artists to continue to do so. So, and if we also think about the impracticability of paying every creator, it also means that you would have intermediaries, collective licensing organizations who would collect this payment on behalf of creators and charge administrative fees. So when you think about it, how much would eventually go to the creator of this one image that is in a million data sets and things like that. So any attribution of copyright infringement to these activities would also affect the scale and rate of AI activities that could be used for socially beneficial purposes. So to push for copyrights to prohibit the use of works for machine learning and other information and analysis activities is to make the copyright bargain unfair to the public and intolerable. And some of the things that we want copyright law to do are not things that the copyright framework set out to do, or things that the copyright framework can do. So some of those things are things that should be subject matter of, say, consumer protection, looking at the unconscionability of some of the contracts that are entered into with creators, or those are things that privacy laws should do, or maybe these are things that employment laws should do, but those are not things that copyright law is built to do. So I'd like to end with this really long quote from David Weber, as a reminder that users are rights holders too within the broad sense of copyright. So the Copyright Act lets users carry on a wide range of activities without needing to worry about copyright in the narrow sense. What the Act specifically permits is not infringement. Whoever does the permitted act is not just taking advantage of a limitation, an exception, or a loophole, or even gracious indulgence in the Copyright Act. That person is exercising a right that is inherent in the balance that the Copyright Act strikes between creators and users. So user rights need to be as liberally interpreted as owners' rights are, lest copyrights become instruments of oppression and extortion. Thank you, everyone.